discrimination in the Employment Act, the Americans with Disability Act, and the Genetic Information Non-Discrimination Act. And why our laws are so powerful, they don't just apply to employees. A lot of times people are just thinking about the hiring and firing. It's also for applicants and employees as well, and it protects from discrimination on all the big ticket items. So we're the agency that deals with race, color, religion, sex, sexual orientation, gender identity, pregnancy, national origin, age, disability, or genetic information. And again, more than hiring, firing, promotions, trainings, wages, benefits. Our laws also prevent retaliation and harassment. So when you think of the big ticket employment issues, such as the Me Too movement, pay equity, the women's soccer team, diversity, equity, inclusion programs, that's really all here at our agency. And we're not a part of the Department of Labor. We are an independent agency, like the National Labor Relations Board, like the FTC, SEC. We're independent. There's 5 commissioners. All of us have to go through the Senate confirmation process. And then there's a general counsel as well that is also Senate confirmed. Our mission is to prevent and remedy unlawful employment discrimination and to advance equal opportunity for all in the workplace. In addition, we have our local partners. So we call them the Fair Employment Practices Agencies. These are our state and local agencies responsible for enforcing
Commissioner, I don't know if you can hear us, but we've lost sound and it looks like your computer might have frozen. Let's give it 1 second, folks. I know he had said he'd had to restart his computer earlier. He may be having issues again. He may need to restart and rejoin. Give it 1 second. Sorry.
I don't know what happened there.
There he is.
Where did I get cut off?
You were just talking about, I think you had just finished talking about the commissioner and the council being commissioned by, or being run through the Senate for their commission.
Okay, yeah, I don't know what happened. The Zoom just completely disappeared and then reappeared. So, but we're good now, right? Did you hear me talk about our local agencies?
Yes, sorry,
Okay.
You did get to that.
Good. All right, so just in the last few weeks, we finally released our fiscal year 22 numbers, just to show you the overview of discrimination in the United States. We collected $342 million for more than 33,000 victims of discrimination in the private sector and state and local governments through our mediation, conciliation, or settlement. So, we kind of lump our enforcement in 2 different areas: the federal government and then state, local, and private. So within state, local, and private, outside of litigation, we recovered $342 million. Around $40 million we collected, an additional $40 million related to lawsuits. So those were like the settling of lawsuits or, the conclusion of lawsuits. And then $132 million for federal employees and applicants. So you think about that's a pretty big number there, $132 million, because we enforce our laws against the federal government as well. So, we see every case of discrimination in the United States. So whether you work for state, local government, or whether you work for private sector, you have to come to the EEOC first before suing your employer. So we received, and just at the federal level, not at our state partners, around 73,485 new cases of discrimination last year. Now, that was a pretty big bump from the year before, which was around 61,000. So that's almost a 20% increase in charges we saw between 21 and 22. We got around 475,000 phone calls from the public about potential claims of discrimination, around 70,000 emails about potential claims of discrimination, and that's also an increase as well. So you see a lot of phone calls, a lot of potential inquiries of discrimination coming in, but what actually turns into a charge of discrimination, which initiates a federal investigation against the employer, was around 73,000. So we were successful in 44% of our conciliation. So what conciliation is, before the EEOC can file a lawsuit, but after it's found reasonable cause that discrimination has occurred, we have to conciliate, which is, like, think about it more of a settlement conference. So 44% of those wound up settling in that process then before moving on to litigation. We filed 91 new lawsuits last year, 53 on behalf of individuals, 25 non-systemic suits with multiple employees, and 13 systemic suits. And those systemic suits are the ones on a policy that wind up affecting large swaths of employees at a specific company as well. We resolved 96 lawsuits last year. And, when we get to the lawsuit stage, we're pretty successful. 94.8% of all those 96 cases settled were in our favor, in the employee's favor. But, aside from the enforcement, we really do continue to focus on mediation. And if you do have a case with the EEOC, our mediators are free. They're trained as investigators. They really know their stuff, but they are neutrals. And we conducted around 6,500 successful mediations, resulting in $170 million in benefits for the charging party. So again, if you are faced with dealing with an EEOC charge of discrimination, no matter what side you're on, I really encourage you to get into our mediation program, because it really resolves the charges faster than litigation, faster than lengthy investigations as well. So for those of you in the federal government sector who are dealing with employees related in the federal sector, we resolved around 9,300 federal sector hearings, securing about $125 million for federal employees through our hearing program. We, in our federal appeals program, if you deal with that, we resolved around 4,000 of those cases in the federal appeals sector as well. So just an overview of where our statistics were from last year. And I do want to show quickly how COVID impacted charges of discrimination. And obviously, this is a very hot topic and continues to be a hot topic as we start to see employees return to work, as we start to see employees suing related to COVID. Because employees generally have around 300 days to file a charge of discrimination against their employer, it's really hard for us to determine whether they were COVID related or not, right? So it comes in as disability discrimination, religious discrimination, and then we have to peel back the curtain a little bit to see if it's COVID related. So we did a snapshot from April of 2020, really the height of when the pandemic started 3 years ago, believe it or not, through December of 2021. So that really dicey period for employers. And we disclosed that there were around 6,225 COVID related charges of discrimination under federal civil rights laws. So of those 6,225 charges, 66% of them, again, just during that snapshot window, related to Americans with Disability Act violation. So that's where we saw the big cases coming in related to reasonable accommodation, saying I want to work from home, or I need proper PPE, or I need, to work in with plexiglass. You remember the early claims of that? So it was really under disability, saying that, I'm susceptible to the virus, I need an accommodation, and employers weren't doing that at the time. Of the 6,225 COVID cases during that snapshot, 2,700 of them related to the vaccine. And we'll see how this number increases, because this was still early on as the vaccine was still being developed. It wasn't as widely available yet. But as we saw employers starting to mandate the vaccine, and there were a lot of instances in the news where large employers were doing that. And then when state and local governments, or if you remember when OSHA was trying to push for a nationwide vaccine, we started seeing a lot of the claims related to vaccination. So of those initial snapshot of the vaccination related claims, 2,400 out of the 2,700 were related to Title VII. That we could say is related to religious discrimination. And that was really the trickiest part looking back related to COVID for employers and employees, is suddenly, and I don't know how many of you on this call are in the healthcare industry, but a lot of healthcare facilities understood how to deal with accommodations related to vaccine, such as flu vaccines, meningitis vaccines, familiar with being able to exempt certain employees who had religious beliefs. But now when the vaccine mandates were looming, every industry had to deal with this. Every industry, for the first time, really had to deal with questioning their employees' faith. And that had never really happened before. And you never really had to question the sincerely held religious belief of your employees. But under the law, you were allowed to do that. And this is when we saw the spike of a lot of people going on the internet and going on the church of the internet and paying $30 for those forms that said, I'm religious. And employers were in a really tough position. Do I need to take that at its face, or do I need to question this person? Do I know this person goes to mass every single day, during work for years, and we believe them, versus somebody else who we know does unholy things on social media? It was a really very tricky part for employers to deal with. And, so we saw a lot of charges related to that. And what got even trickier is there's even cases where some employees got the first shot, but then didn't want to get the second shot because, they found God between the first and second shot. And, for you as your employers or representing employees, as ridiculous as some of these claims may sound, you have to take it seriously on an individualized basis related to their religion, and can be an ongoing discussion. You could grant an employee exemption from religious reasons for COVID vaccination, and then later on question them. So it was a really difficult time, and we'll see how the spike of religious discrimination claims come when we break down the more granular 73,000 charges. But I do think, that is kind of slowing down as mandatory vaccination programs have largely gone away, or as other individuals are not requiring it or getting the shot anymore. But it was just a really interesting time in the space for the EEOC to deal with. So, but long lingering effects related to COVID. Now we're dealing with the return to work issue, about employees having the right to return to work. A lot of employees will say that they're more productive at home, that they've made the company more money at home, and that they're enjoying working from home, and they don't ever want to come back. And this is a really tricky situation for all of you now, no matter what side you represent, is because, largely before the pandemic, if, an employee didn't want to come to work 5 days a week, they'd be fired, right? I mean, that's it, come to work. But now, since employees have gotten used to working at home, the difference is now the business decision of, are you going to require your employees to come to work every day because you want to, because employers still control the essential functions of the job, whether or not the employee likes it or not. The question, and what's going to rise, and what you all need to be careful about, is now accommodations for working from home. And when does an employee have an actual federal right to work from home? And again, this is a very novel area. And what we're seeing now is the rise of mental health claims. So, generally you wouldn't have to make an accommodation for an employee who wanted to work from home or return to work. But now we're seeing employees coming and saying, under the Americans with Disabilities Act, I have a disability, and that disability is related to my anxiety, and my disability is related to depression, to other mental health claims such as PTSD. And we're seeing a rise in those charges as employees become more aware of mental health, of the toll COVID took on everyone. But now there may be a legal right for that employee to request an accommodation, if possible, of telework. So that's going to be the next new challenge for Human Resources Department, is how are we going to deal with these employees who make requests to work from home when it's related to a mental health disability under the ADA? And what are we going to do to solicit that information? Because unlike physical disabilities, largely these are invisible, right? I mean, normally ADA interactive process and accommodations prior to this really dealt with that. I have a physical limitation. To be able to come to work, you need to, pay for a very expensive keyboard or whatever, whatever it was. But here with mental health, it's largely going to be on employers to deal with the employees' requests to see if, I have anxiety of returning to my normal commute. I don't want to go on the subway anymore. I'm fear of the next train. So before, when in a way, there's no other way to say it, employers would laugh it off if you say you don't want to come to the subway to work. Now you have to take that very seriously, because now it may rise to disability. And it's sort of a warning in the sense where we're seeing these claims coming in, and this is largely going to fall on the employees to disclose that to HR, and HR to be able to have those accommodation requests coming in the door. And we're going to largely see it returning to the office. So before I get into artificial intelligence, I just did want to mention we are working on our 5-year strategic enforcement plan. This is a document that we do every 5 years, set the tone of the agency of where we're going to be enforcing. And so there's going to be an emphasis in the draft plan on artificial intelligence, which I'm about to discuss. Pay equity is going to continue to be a really big hot ticket item here in Washington, D.C. and around the country. This is a little different than what you're seeing pop up in states. And I don't think you have it in your area related to pay transparency, but a lot of employers are doing it. What you're seeing in New York and Colorado and California and Washington State, the requirement that employers post the pay ranges in those jobs. It all kind of comes into the larger pay equity conversation related to paying men and women equally for the same work, and also not discriminating on any other protected characteristics related to pay. So you're going to see a continued big push out of that in Washington. Under the pregnancy discrimination laws, as a lot of you probably know, Congress amended or passed the Pregnant Workers Fairness Act in December. That is now for the first time a legal right for pregnant employees to have accommodations both in the application process. Before, there was kind of a loose standard on pregnancy accommodations, but now under federal law, you have to treat that very similar how you would treat a disabled workers accommodation. So the EEOC has to engage in rulemaking related to that. So be on the lookout for that. We're going to try to provide very easy to understand examples of when you have to accommodate pregnant workers, both in the application process, during their pregnancy at work, and then post as well. And then other issues that are of hot topics here, always related to systemic harassment, those larger systemic cases where policies or procedures of the employer, creates a significant issue for one protected characteristics over the other. And then obviously related to current events and COVID, how that continues to affect the workforce. So I wanted to kind of give an overview first of the EEOC, where we are discrimination-wise and some of the hot topics before now diving into a subject that I'm really excited to talk about. So, artificial intelligence is in the news everywhere with ChatGPT and everything else. And in a sense, to me now, that's kind of a large distraction in the sense where it matters in our space. And when I first started diving into AI in the workplace, a lot of people just kind of pushed me off saying, oh, you're talking about automation and replacing humans with robots. And, there was a lot of scary statistics out there that sort of had people thinking that. The World Economic Forum predict in the next 4 years, 85 million jobs might be displaced by artificial intelligence. A study done, to freak people out more on this as well by the Brookings Institute here in Washington, D.C., examined the overlap between the text of AI patents and the text of job descriptions in the Department of Labor's database. So of the 769 job categories included by the Department of Labor, 740 of those job categories had some near-term risk of automation. And then, as far as the companies actually using robots, it may be cheap to do so. There's some studies out there that saying building and using a robot that costs $10,000 a year can displace 2 to 4 humans for $10,000 a year. So as the labor shortages linger, you see a lot of companies moving in that direction. So most of the conversations about artificial intelligence in the workplace were around this dystopian future. But what I want to talk about today, and from the standpoint of AI and workplace anti-discrimination law, the future is already happening. But I want to start first, what is artificial intelligence in an easy to understand definition that the conference board put out. And essentially, dumbing it down for non-computer scientists like myself, it's just a technology that mimics human thinking by making assumptions, learning, reasoning, problem solving, or predicting with a high degree of autonomy outcomes. So that this is a big umbrella of things like machine learning, natural language processing, deep learning, whatever you want to call it, kind of just gets swooped up into that mimicking human behavior. And here's where it's critical to human resources and labor and employment. HR departments today have more information about individual workers and about their workforce as a whole than ever before. But again, that information is not the same as knowledge. That information needs to be read and assimilated in order for it to be understood. And that's where AI comes in. It takes all this information, it culls and correlates it on a massive scale to make workforce related predictions. And that's tracking into huge business. In 2021, HR tech spending was already at $17 billion, and it's supposed to go up to $30 billion in the next 5 years. But this didn't happen overnight. And the reason I'm talking about AI and the reason the EEOC is looking at AI is that it's already been involved in the decision-making at every stage of the job life cycle for years. So whether you're aware of it or not, AI writes job descriptions, screens resumes, chats with applicants, conducts job interviews, and then predicts if an employee will accept an offer. And in some cases predicts how that employee will then interact with their new coworkers. It identifies employees' current skills and potential skills. It tracks productivity. It assesses workers. And nowadays, if employees fall short of expectations, an AI algorithm may even send them a message saying that they're fired. So this isn't a forward-looking prediction. For each of these tasks, you can find a commercially viable product for purchase right now that these tech vendors are willing to sell. And look, the pandemic obviously moved forward the implementation of a lot of these technologies. And the fact is that AI is now making a lot of decisions once, made by humans before in HR. It's not necessarily a bad thing. It's not necessarily a good thing. At the risk of sounding like a lawyer, which I am, it really all depends. And the really careful and a key takeaway from this whole conversation is that if AI is carefully designed and properly used, it actually does have the potential to advance diversity, inclusion, accessibility in the workplace by mitigating the risk of unlawful discrimination. So, all of you are in this field, all of you have seen, have witnessed, have dealt with the numerous ways that employment decisions are vulnerable to bias on the part of hiring professionals. That's the reason, one of the many reasons my agency exists. For example, one study showed that hiring managers are more likely to favor resumes featuring male names over female names, even though the resumes are otherwise identical. Another study showed that African Americans and Asian Americans who whiten their resume, and what do I mean by that? Deleting any references to their race or associations with their race, receive more callbacks than those who included those racial references. And the other issue is that HR professionals do not become aware of discriminatory conduct until it is generally too late. But AI can help eliminate bias from the earliest stages of the hiring process. So an AI-enabled resume screening program can be taught to disregard variables that have no bearing on job performance, such as an applicant's name. And think about it. What does an applicant's name tell you about that person's ability to do the job? Nothing. But what it does tell you is things the EEOC says you're not allowed to make a decision on, such as their sex, their national origin, their religion, or race. Likewise, an AI-enabled program that conducts preliminary screening interviews can be engineered to disregard factors such as age, sex, race, disability, and pregnancy. It can even disregard variables that might suggest a candidate's membership in a protected class, including foreign or regional accents or speech impairments. And in some cases, replacing an interviewer with a bot. And a lot of companies are doing this, especially that ones that need to hire in mass scale. Your entire interview is on your cell phone, and it's an app, and a robot is basically talking to you. But if you think about that, what does that do? It does eliminate intentional discrimination at the earliest phases of the hiring process. So it's not unheard of for an interviewer to meet a highly qualified candidate, let's say who's pregnant, disabled, or religiously observant, and think to themselves, this person is going to cost me, accommodations will cost me, healthcare will cost me, leave will cost me. This candidate just isn't worth it. So I'm going to go with somebody else who won't make those requests. Now, you don't need to tell me, I know this is a very highly illegal example and you can't do that. But for that person who didn't get the job and they get the rejection letter just saying, oh, we went with somebody else more qualified, they'll never know that person who interviewed them made that decision based upon that discriminatory animus there. So this is an example of where AI may help, because AI can't see you in that first interview. If it's just listening to the words you're saying, it doesn't see all those things. If you think about an interview, or on, now a Zoom interview, the first thing you see a lot about that person, a lot of things you're not allowed to make decisions on. So some potential good of AI. So now just flipping everything I said earlier, if AI is poorly designed and carelessly implemented, here's the problem. It can discriminate on a scale and magnitude far greater than any individual HR professional. Like any bad HR decision, poor uses of artificial intelligence will damage the organization, create a toxic work culture. And because AI is only as good as its purposeful and insightful application with an eye on actual impact and compliance with the law. So in our case related to labor and employment and HR, purposeful application of AI means careful consideration of everything from the quality of data being used, which is, we'll go over examples such as the candidate pools, to the monitoring of the algorithms after it's been deployed, what the results are. That's because the predictions AI is making about specific applicants are only as sound as the training data on which the algorithms rely. So for example, a company that relies on the characteristics of the company's current workforce to model the attributes of the ideal applicant may unintentionally replicate the status quo. So if the current workforce is made up primarily of employees of one race, one gender, or one age group, the algorithm may automatically screen out applicants who do not share those same characteristics. And sort of the most infamous story now in this space that has kind of become legendary is that employing this metric at a resume screening company, a company went to one of these resume screening AI programs and said, here are our best workers, go find us more of them. Go use your fancy machine learning and AI to find what the likely predictors of success are at our company. So that program, which was sold based upon furthering diversity, equity, inclusion, came back and said the most likely indicators of success at your company were being named Jared and having played high school lacrosse. So this is an example where, not necessarily that the AI was discriminating, it was just a function of the current workforce when you're asking it to replicate that as well. So where this all comes in is that it's also being kind of swooped into for employers who are buying AI to make decisions more efficiently, economically, and effectively. So you think about other uses of AI for looking at documents, for looking at accounting, whatever the issue is, that's the end result. Faster decisions, more economical decisions, more effective decisions. In our space, a lot of these programs promise to advance diversity, equity, inclusion by mitigating human bias. So because of the way AI is coming in the market, for companies, especially larger ones, deciding whether to adopt HR technologies is no longer going to be a hard choice, but deciding which to adopt and for what purpose is going to be where the hard choice is. So you know about our mission at the EEOC. The laws we enforce here really predate by over half a century the AI technologies I'm discussing. Nevertheless, our laws are as applicable to employers who use AI to make employment decisions as they are to employers who rely exclusively on HR professionals. In short, really all the different types of use of AI in the workplace apply equally to our laws from the 1960s. So now, without giving a full labor and employment law school lesson, I do want to just quickly go over two theories of discrimination and then apply them to AI. So, generally there's two theories of discrimination known as disparate treatment or disparate impact. And you can think of it generally as intentional or unintentional discrimination. So under disparate treatment, an employer deliberately treats some people less favorably than others based upon their membership in a protected class. For instance, their race, sex, or religion. So for the easiest example of disparate treatment is I have a stack of resumes. I want to discriminate against women. I'm going to go through and look at every application to see if it's a woman. And if it is, I'm going to throw that resume in the trash. Pretty intentional discrimination. Disparate impact discrimination is when an employer has a practice that's neutral on its face and has adverse impact on members of a protected class. Now, the most basic law school example of this is a company wants to just hire workers who are going to show up to work on time. That's the only qualification to work at this business. So to do so, to further that policy, they're saying we're only hiring you if you live in the zip code next to the office. So if the zip code next to the office is predominantly made up of members of one race, for instance, the policy then may have the effect of excluding members of other races from the job opportunities, even though the intent of the policy was only to make sure that people came to work on time. So with the disparate treatment, that intentional, it requires a showing of discriminatory intent. But where it's tricky is that disparate impact does not. And here's where it's tricky for employers, especially when it comes to AI. Employers are equally liable for discrimination, whether or not they intended to discriminate. And this is absolutely crucial thing to bear in mind as companies start going all in on HR technologies. In HR, data is everything. It makes a difference between a good hire and bad hire, a good promotion and a bad promotion. And what I'm trying to raise awareness of, it's a difference between lawful and unlawful decisions. So, if you think about the intentional discrimination use of this, how long it takes somebody to discriminate, I don't want to say old fashioned, but going through resumes, right? It takes time. You have to sift through it. And where you don't really know what that person is thinking when they're discriminating. And what are we left with now? You talk so much about the black box of algorithms and how we're going to figure it out, but what are we left with now? We're left with the human mind, which is difficult to understand. And we never know what a person's true motives is. But this is where, AI, again, if it's carefully designed, can correct for that black box problem. It can mask for race, gender, age, disability, and other characteristics. It can mask for proxy terms like the examples I gave you earlier, people's names, people's graduation grade dates, or sports teams. So it can potentially help employers take that skill-based approach to hiring, which is, all the rage now of what employers want to do. It can really help identify candidates based upon not only their merit, but their opportunity and potential, all with stripping human bias. But at the same time, as you heard before, AI can replicate and amplify existing bias when it is improperly designed. So now that you get the two major overarching legal issues, I want to apply AI to each of them. So for the disparate impact of unintentional discrimination, the most well-known example is with a program that Amazon tested between 2015 and 2017. Their programmers fed the algorithm a data set consisting of resumes belonging to Amazon's current employees, along with resumes that had been submitted to the firm for the prior 10 years. So using machine learning, the program was able to identify patterns in the historic data set and then use those patterns to rate new applicants on a scale from 1 to 5 based upon their resumes. However, because the vast majority of resumes in the data set belong to men, the program began automatically downgrading resumes with certain word combinations, such as women's sports teams, women's clubs, and the names of women's colleges. But there was no proof of misogynistic intent on behalf of the AI. It was just a function of the data fed to it in the first place. So when it comes to AI, legal scholars, software engineers, and vendors really tend to focus on this unintentional discrimination based upon those data sets. But claims of AI discrimination can easily and often and do fall under the umbrella of disparate treatment, that intentional liability. And you may be thinking, well, how's that possible? AI, it really has to be on the data. AI doesn't have a mind of its own. There's one illustrative example of this, and it's not an EEOC case, so I can talk about it. There's a class action suit against Facebook's advertising practices, including its use of AI algorithms, saying it violated state anti-discrimination law. So in the court filings there, the plaintiffs alleged that a number of companies restricted their employment ads to certain age groups in violation of age discrimination laws. The lawsuit alleged that employers could create a tailor-made applicant pool by simply ticking off boxes on a list of characteristics. So you could have check an include box next to preferred characteristics or an exclude box next to disfavored characteristics. So think about that with age, sex, national origin. Just with a few clicks, you can completely eliminate a lot of people from ever seeing the advertisement. So no surprise, shortly after it was filed, the Facebook said that it would be disabling a number of advertising features, including this one related to employment, and that they would have a separate advertising employment portal for employment ads. So here's the issue. Aside from job advertisements being federally protected, allowing employers to exclude people from their applicant pool in the manner alleged in this case goes even further than the pre-civil rights job advertisements directly telling people of certain races, religions, or national origins not to apply. Now, we've all seen those job advertisements from New York City in like the 1920s, 30s, black and white, in the signs like no Irish need to apply is the famous one, or just put whatever religion. If you look at some of the historical job advertisements, there's crazy ones like no women of childbearing years apply, and just add your protected characteristic. But the difference there, and of course there was no civil rights laws at the time, but if there were, you could see you're being discriminated against. You were told you were not able to apply for this job based upon protected characteristics. The difference here in using technology is that it withholds the very existence of the job opportunities for members of a protected class on the very basis of their membership in the protected class, leaving them today in 2023 unable to exercise their rights under civil rights statutes. After all, you can't sue for exclusion from a job opportunity if you don't know that job opportunity existed in the first place based upon your protected characteristics. So in an instance like this, with just a few clicks, AI can help employers engage in this intentional discrimination on a scale and magnitude far greater than we've ever seen before. Because as you know, under our laws, that anyone who didn't see that job opportunity, who was qualified and said they would have applied, could essentially sue for discrimination that they weren't provided that opportunity. So you can see how large these cases can quickly become. So, as you well understand at this point, AI does not have any motives or intentions of its own, and just has its algorithms that allow it to correlate data. And then that's what's making it so attractive to employers. Its reliance on hard data creates the potential to eliminate discrimination by removing the human bias from that decision-making. And if it is designed in a clear and explainable way, it eliminates one of the biggest challenges, which is the human making the decision and injecting bias in it. But, the apparently objective nature of algorithm decision-making can result in technological bias on the part of the user, that is in over-reliance, if not blind trust, that the robots are always going to lose sight of the fact that AI is self-reinforcing and requires close monitoring. So you can't have a set and forget it approach to HR technologies, because inaccurate, incomplete, or unrepresentative data is only going to amplify rather than minimize that bias in decision-making. And that's what we saw in that Amazon program I showed you before, how biased inputs can yield biased outputs. And it's funny because although that is in the labor and employment space, that example is used widely at, AI academic.
Let's give him a minute. I'm guessing he's having the same difficulty again. Sorry, everybody.
When it proved unworkable, they abandoned that program without ever actually using it to make a hiring decision, which is basically how we all know about it. But like I said earlier, it's not just being used to hire, it's being used at every stage of the employment life cycle. At the pre-hiring stage, though, AI does has the potential to make recruiting more inclusive. For example, there's some programs out there that use what's called natural language processing to help employers write job descriptions that promote greater diversity in their applicant pools. So the way a job description is written, the specific words used, and the way the requirements are described, there's been many studies have significant influence on who applies. So there are now programs out there that compare the linguistic patterns in a job description with historical applicant behavior and correlating hiring outcomes to find out which word combinations are most likely to attract applicants. In fact, one AI program claims it can predict which word combinations are most likely to attract applicants based upon gender. And it provides real-time feedback to employers on how likely their word choices risk alienating applicants of one gender or another, enabling the employer to aim for maximum inclusivity. And this is really, important if you think about it. Job descriptions are loaded with historical bias because a lot of them are just copied and pasted from the internet, from their competitors, and you don't know what words you're putting in there. You don't know what qualifications you're putting in there for your workforce that may exclude people from certain protected characteristics. And the classic example is in Silicon Valley, where it's common, say, for these coding positions, where I want a ninja coder. I want a rock star. It's just very common ways you describe these coders. But, a ninja or a rock star can really prevent a female. And there's been studies showing this from applying. So using AI to say, well, these words, are likely to alienate certain people can be really helpful in that. The job advertisements as well. A lot of example I mentioned earlier that I want to talk about, and happy to open it up to any questions, is, using an app to do the job interview. So for large employers, when Target or Walmart say they want to hire 40,000 seasonal workers for Christmas, how are they going to interview 40,000 people? They have to hire 60,000 people to hire 40,000 people. So that's where you're seeing, this technology being really good in a sense where you're really being based upon the quality of your response versus otherwise. So,
Commissioner, I'm so sorry
yeah.
to interrupt you. You got frozen there for a second, right about the point you were talking about those 40 and 60,000 employee numbers. I apologize.
I'm sorry. I don't know what is with the internet here today, but have I been okay the rest of the time?
I think there was one other where you glitched out for just a second. But if you want to just go back to where you were talking about the numbers about, I believe it was Walmart you were talking about.
To answer Sandra's question, I have I wrote around a 90-page law review article with my team here that I will send around that really goes for this in detail. So, but, for the practical examples of what I'm talking about related to, when you have to hire 40,000 seasonal workers, what are you going to hire 60,000 people to schedule and coordinate 40,000 interviews? It's just not practical anymore. So, the AI out there that you do your entire job interview through your phone that takes your voice, so it can't see you. And it's actually looking at the words you use in the order you use them and assessing the quality of your response based upon what the employer's expectations are, can really actually allow an employer to hire, without bias based upon the order that how they respond to the question. So that's good, right? But at the same time, if somebody has a thick foreign accent and the computer only picks up 50% of what they're saying versus somebody who speaks fluent English, who they can pick up 99%, that person with a thick foreign accent is going to be rated lower solely on the basis of the computer not being able to pick up their accent, even though the words they are using and the way they're responding to questions may be better. And that is national origin discrimination right there. Or if a person has a disability and they stutter, and even though their answers would be better if they're being recorded and it's not picking up all of their answers because of that disability, that's disability discrimination right there. So you see how quickly these really beneficial programs can then turn discriminatory. And then I will conclude with the final example, which is one of the riskier examples of this before I take any questions, is related to facial recognition. So there's now programs out there, when you're doing your Zoom interviews that have facial recognition algorithms running. And they, one of the programs says almost 30% of your score in some cases will be based upon your affects of how you move. Or, in some, say for a sales position, say that employee during the interviews, they want to rate you on how often you're smiling. And we say the only qualification to working as a salesperson in this company is if you're smiling and looking at the camera the whole time. And, there's algorithms out there that can actually measure that. And this is where it gets really tricky, aside from, is that really the best way to determine, your skills for the job? But what happens if you can't smile? What happens if you are the best salesperson, but the country you come from, you're not supposed to smile during sales and you would do great? So at that point, again, you could see where the disability discrimination comes in, or the national origin discriminations in based upon using facial recognitions. That's, of course, even if the computer can see you. And, the MIT Gender Shades Project did a study related to the dominant commercially available facial recognition algorithms. And what they found was if you're a white man, the AI can pick you up 99% of the time. But if you're a dark skinned female, it starts between 65 to 74% of the time. So, right there, if you're a light skinned male, you start here, and you're dark skinned female, you start here. You could see by my hands the discrimination that will occur right off the bat that you can't even be seen. So, it's really, what I'm trying to raise awareness of for all these programs, there's a lot of potential ways to eliminate bias. But at the same time, if they're not carefully designed, if they're not taking into these metrics, such as the examples I gave you before, they could just increase discrimination to the likes we've never seen before because it's so scalable and you're able to implement this for your entire workforce. And then obviously now there's programs out there that's monitoring employees, that's doing performance reviews for employees, that's telling employees what their job duties are for the day. Without that human element, without that touch of saying, well, can this employee really perform all these functions without an accommodation because of a disability, without an accommodation because of a pregnancy? And if you're using AI just across the board to do these management functions, which previously had taken, that human element of engaging in the interactive process, if it is based upon a need for religious accommodation, a need for disability accommodation, an AI just can't figure that out, can't pick that up. So, using AI for management purposes can completely also violate the Americans with Disability Act. In addition to, if you're in a factory or retail and your manager is essentially an app that's giving you your job for the day and you do have a disability and the way you communicate is through a chatbot, are you willing to disclose some of the most detailed personal characteristics of your health? Or now, as I said before, with mental health into an app that goes nowhere. So is that going to limit the employee's ability to engage in that protected interactive process? So you could see, again, from the efficiency standpoint, from a discriminatory standpoint, we're really at a time now where these programs are really getting out there pretty quickly, but they have to comply with our long standing laws. So that is sort of an overview. I can send you some more written material where I get much more in depth on these issues, but I'm happy to take any questions.
It looks like we have a hand up. Brad.
Hey, Commissioner, thank you so much for speaking. I'm a law professor and an arbitrator, and I teach employment discrimination every year. I found your comments very interesting, helpful. First of all, I have one comment and then one question.
Yeah.
My comment is I love that you framed your talk in terms of both promise and perils, because this seems like an issue where you hear a lot about perils and other professors and other people commentating about all the concerns with algorithmic moves that are being made. But of course, we have to compare that to the alternative, right? And I hear what you're saying, that it could be more dangerous because you could eliminate more people from even knowing about an opportunity in one fell swoop, but you can also replace that human subjectivity. And there's a lot of promise there. It makes me think of the move to get rid of standard. I know this is not a perfect analog, but it makes me think a lot of times about the move to get rid of standardized testing because of concerns about, impact, like with the algorithmic stuff. But, if you get rid of something that's structurally flawed, what's taking its place? And do we think that those alternatives are better? And to me, with algorithms, I think it's always a comparative thing, right? Do we think this could be an advantageous move? And of course, the answer is yes, if we trust the inputs. My question,
really great point on that too, because it's a lot sexier to talk about what you're seeing in the news of, these robots taking over and it's going to be biased. It's going to discriminate. That's really what a lot of people are talking about, but there are really significant benefits to using it here, not just from an efficiency standpoint, but from removing bias from, this that has plagued the workforce since before these laws existed. So I really just try to highlight both. So I do appreciate that comment very much.
Yeah, and my question was just about the Pregnant Worker Fairness Act.
Yep.
Is it anticipated that it'll be interpreted, reasonable accommodation and undue hardship will be interpreted in ways that track sort of with the ADA's jurisprudence on this? Or here I'm thinking of the way in which We had the Rehabilitation Act, and then the ADA was passed, and we thought certain definitions were going to carry over and be interpreted the same way, and then they weren't. We had to amend it. And so I'm wondering here if there's reason to believe that these terms will be interpreted in much the same way.
I think so. And I think what we're seeing now too with the case at this Supreme Court with religious accommodations. So for those of you who don't know, there's a case that's going to be argued in front of the U.S. Supreme Court relating to the 1970s TWA case related to religious accommodations in the workforce, which has a lower standard for accommodations for employers than the Americans with Disability Act. It has basically a de minimis standard for the undue burden for employers to take for religion, but for thinking of disability, they basically have to spend money, and it's hard to meet that. So, this year we may see all three of those kind of just mirror the ADA. Most Supreme Court commentators say that this court is going to undo that standard and put the higher threshold for get rid of the lower threshold for employees asking for that religious accommodation and go to the ADA standards. But for the Pregnancy Workers Fairness Act, what we're seeing now too, I think we go to rulemaking that it is going to be similar to the ADA. We're engaging that interactive process. And that standard of whether or not the employer has to make that accommodation is very much going to be judged on, can you still do the job, obviously, without being a direct threat analysis potentially to other employees and yourself. And also, what's it going to cost, which is going to be a harder standard for employers to prove. So that's where I think it's going. And I also think that's where religion is going to go as well. So in a sense, for HR departments and employers and employees, having all three of those, which, prior to this year, were all three different standards. The pregnancy was under the UPS versus Young standard, which was basically saying if you didn't have a comparator and you're a pregnant employee, then you would have to stand on your feet for 10 days. You wouldn't be for 10 hours. You wouldn't be able to go to the bathroom unless somebody else is doing that. So that's resolved. Now we're going to see with this religious too, that the employer, instead of saying, and the issue with this case was go find somebody to cover your shift, we don't actually have to move somebody around, of now having to move somebody around. So in a sense, it may be easier from a compliance standard if all three are the same, but I do think you'll see more companies, whether or not they're required to just go to the same standard for all three across the board. But that's where I think the Pregnant Workers Fairness Act is going with rulemaking, that it's just going to mimic the ADA.
That's very helpful. Thank you.
Other questions?
I put the in the chat that long form article, and then also I put the EEOC's guidance. We did, I didn't get a chance to mention, in May of last year, we put out technical assistance related to the Americans with Disability Act. Low hanging fruit for FRAI, especially for a lot of the programs that require you to do your application online, whether it's playing games or just access to computer, and how employers are going to have to set up alternate systems for those with disabilities who can't participate in those as well. So that was our first area of technical assistance.
Thank you so much for those. I'll actually add those in, everybody, to the email with the link for our survey for today's presentation. So everybody, you will get copies of those two links in the email I'll send out in the next 5 minutes or so. Any other questions? If not,
I have one more if nobody else has any.
Go ahead, Brad. And Brad, we could talk anytime too. So this doesn't have to be the end.
Okay. Well, I don't want to hold
Bring
up.
the question.
Okay. Well, so I had one more question. It made me, I was thinking about the examples you were given, seemingly disparate examples of, like facial recognition technology and algorithm stuff. And it occurred to me, one thing you're talking about with both of those is sort of like privacy and anonymity, and the role that those can play in preventing discrimination. Really is what of course they can further it, but they can also prevent it. So I wonder, like, how the EEOC, how you all talk about privacy, because of course, there are all these ways, whether it's under the ADA with minimizing medical examinations, or it's under Title VII with sort of creating soft norms around asking about certain types of information. And now with algorithms, we're talking about sort of shielding candidates, creating some anonymity. But with facial recognition, we're using technology to do the opposite, right? We're making people in some ways less private or less anonymous. And so there's more room for there to be error. And so I just wondered
Yeah.
if you could speak generally about like how you see privacy and anonymity and these things playing a role with furthering the mission of the EEOC.
Yeah, it's a little weird, different here because outside of the, keeping employees' medical information records separate from their HR file and not seeking medical related inquiries that's unrelated to the job, employees don't really have a lot of privacy when it comes to work in our space. Where we're seeing more of the action is with the National Labor Relations Board, and they've put out some guidance on this related to how they are saying that, well, okay, so all these programs we told you about, the one that are monitoring how many widgets you're building a day, or monitoring your interviews, are they also, there's a lot of programs out there that go through your Teams or your Slack or your emails or your Word documents to see what your sentiment is for the day, to see if you're a flight risk. But are they also then spying on you in a sense to prevent you from unionizing, to discussing your salaries, to things that are protected under the National Labor Relations Act? So that's more where we're seeing it there when it comes to privacy, is it impinging on your Section 7 NLRA rights to have those discussions with your coworkers, less in the EEOC space, other than the medical information side, which you pointed out.
Well, thank you so much, Commissioner. This was an excellent lecture today. This was very, very interesting. You've had a lot of folks in the comments say thank you and how informative and truly outstanding this was today. We really appreciate you being here. And I believe Mito will be mailing you a pin set as a thank you for
Cool.
having lectured for us today. So
Yeah,
I will
keep in
I will
touch.
remind her.
I'm on I'm on LinkedIn. I'm happy to connect. And as I continue to put out more information related to this.
Well, thank you so much. We really appreciated it. And everybody have a great day. We do have a meeting again next month in
Take care.
April. So just as an FYI for everybody to remember, we will have our meeting again in April. And the topic of that meeting, I don't recall off the top of my head. Give me 1 second. It will be with Camille Hebert from the Ohio State University College of Law regarding case law updates related to labor and employment law decisions. So we look forward to seeing everybody. Thank you so much for attending. Have a great afternoon.